everybody. Thank you for joining us today. We're excited to talk to you about U.S. immigration and hiring Canadian talent to assist you with your needs here in the United States. My name is Jeremy Richards, and I'm here along with my business partner, Christine Jurusik. Our law firm limits its practice to U.S. immigration. So all we do is U.S. immigration law and help businesses bring in foreign talent, as well as helping foreign nationals to live and work in the United States. And because of our proximity to Canada, we deal with Canadians on a regular basis. We also help foreign nationals from all over the world. So we don't just help Canadians, but we do have a special expertise with Canadians because we deal with them on such a high level. But no matter where your employees might be from, or we help foreign nationals from all over the world to live and work in the United States. And today we're going to talk specifically about the options that are primarily available if you're working with Canadians. And we're also going to start with a little bit of discussion about the current immigration climate. Immigration is all over the news right now. There's a lot of information out there. Some of it is accurate, some of it is not, and hopefully we can clarify a little bit of that when it comes to working with foreign nationals. Then we're going to talk about the TN visa, which is a specific visa category that is only available for both Canadian and Mexican citizens. The H-1B visa, which is a worldwide visa for individuals that qualify for that. The L-1 visa, the E-1 and E-2 visas, as well as employment-based green card options for your foreign employees as well. So the current immigration climate right now, I would say that the fear and anxiety around immigration is at an all-time high, at least the highest I've ever seen it since I've been practicing in immigration law. And one of the most important things you can do as an employer is make sure that you have your Form I-9s completed and accurately on file, that those are up to date for all of your workers, and this applies to U.S. workers and foreign workers. You're required to have that Form I-9 completed for anybody who is working for you. Make sure you have that on file, that is up to date, and that you have all the required supporting documents for that Form I-9 on file for all of your employees. For employees, it's important that they understand that they carry their proof of their status in the United States with them. And this applies to foreign nationals. So if you have an employee, for example, who is on a green card, by law, a green card holder is supposed to have their green card with them on their person at all times. And the same thing applies to a foreign national who is here on a work visa. They need to have proof of their immigration status with them at all times. And sometimes people are uncomfortable carrying the original document. Maybe they don't want to lose their green card or their passport or their visa. So at a minimum, we'd suggest having them have a copy of those documents with them. So if they are questioned, they can produce, the proof of their valid status in the United States. And again, as an employer, make sure those Form I-9s are updated and on file for all of your employees. If you have H-1B employees, then you would be familiar with the public access file that you also need to have on file. Make sure that those are current for your H-1B employees as well, and you have those in the files for all of your employees. Now, visa processing, you need to be aware that under the current administration, we are expecting and have seen some extra scrutiny in the visa processing, as well as we would expect some delays in processing, especially if employees that have to process through a consulate and get a new visa in their passport. Doesn't apply a lot of times to a Canadian. That's one of the advantages of working with Canadians is Canadians are what is called visa exempt. And a lot of times they don't have to get a visa at a consulate. But if you do have an employee who is already in the United States and their status is coming to an end, maybe they need to extend their status, or you have a new hire who needs to get a visa, plan ahead. most of the time you can apply up to 6 months before an anticipated event. So if you are planning on hiring somebody, try to get that visa as far in advance as you possibly can. Or if it's expiring, you can apply for an extension up to 6 months before the expiration. So it's very important right now, especially with potential delays, to plan ahead. Be aware of your employees' status in the United States and plan accordingly so that they don't fall out of status. Um, and that applies to both your current employees and potential new hires. And overall, what we're seeing under the current immigration climate is enforcement. Enforcement at an all-time high. So what does that mean? Well, it means that if you have employees crossing the border, they can be questioned about their status, what they're doing in the United States, making sure that they are maintaining that status in the United States. So if you have employees that travel often, then it's a good idea that they carry proof of their valid employment. Maybe they carry their current pay statements. Maybe they carry a letter from you as the employer confirming what their role is with the company. So if they are questioned about whether or not they are actively working and maintaining that visa, then they can have that with them at all times. Also making sure that individuals are truthful and honest in their interactions. I think that's one of the biggest issues is people try to hide what the purpose of their entry is to the United States. Also making sure that you do, again, have all of your employee records up to date with those Form I-9s. So if you do get a visit from ICE, if they do a workplace enforcement or the Department of Labor, then you have your documents all in order and you have nothing to worry about. And the enforcement we're seeing are for violations. So as long as you are doing things correctly, you have all your documents in order, and your employees are maintaining legal status, then you should not have any issues in that regard. So make sure you have accurate, up-to-date documents for yourself as an employer, but also for your employees. And people are still getting visas every day. We have clients coming across the border daily, getting visas to work and live in the United States. Green cards are still being issued. So despite what you might be seeing in the media, they're not just rounding up random people on the street and removing them from the United States. These situations, as you see, typically involve violations. Somebody's committed a criminal or immigration violation that has led to their removal or revocation of a visa. So because of that and the potential for being questioned about status, just make sure you have all your documents in order. All right. So the TN visa, if you're not familiar with the TN visa, it's an excellent option that's available to Canadian citizens. And I'm going to also throw in Mexicans because it applies to both Mexican and Canadian citizens who want to work in the United States or who have an offer of employment in the United States. And this is limited to listed occupations on what is called the TN occupations list. And this is under what was formerly known as NAFTA, currently known as the USMCA. And if you have an employee that would fall under one of the occupations that's listed under the USMCA, they could potentially obtain TN status. Well, what are the benefits of TN status? Super fast processing, especially for Canadians. If you have the right paperwork in order, within a week, 2 weeks, you can have that employee show up at a U.S. port of entry, pre-flight inspection point, apply for and obtain status to come and work in the United States under that TN right there, same day within 30 minutes at that port of entry. There's no lottery, there's no cap. So unlike the H-1B, or the H-1B, the lottery just closed on Monday. So everybody's waiting for those H-1B lottery results to come in to see whether or not they got in that H-1B lottery. Well, TN doesn't have a lottery. So as many Canadians or Mexicans that want to get a TN every year and have valid employment in the United States, and it's under one of the TN occupations, they can get a TN. So very convenient as far as that goes. Also, a TN can be issued for up to 3 years at a time with unlimited extensions or renewals. There is no cap. Like the H-1B, there's a 6-year limit. You can get 2 3-year H-1Bs, and then you're done, with some exceptions for extensions depending on whether there's a green card being filed for an individual. Whereas for a TN, you can extend that TN every 3 years indefinitely with valid employment in the United States. No formal employer sponsorship is required, meaning with the H-1B, you have to file what's called a labor condition application with the Department of Labor, and you also have to file for approval through U.S. Citizenship and Immigration Services. And that has to take place before the employee can start working for you. With a TN, with a valid offer of employment, proof of their credentials, they can show up at a port of entry without pre-certification from Department of Labor, without pre-approval from USCIS, and be approved and admitted on the spot with CBP. So much more convenient with a valid offer of employment and proof of credentials. They can get that TN. So very quick, very efficient process, very convenient if you need people to start quickly. Some of the common occupations that you see for TNs that we deal with a lot: engineers and those in the engineering professions, computer systems analysts, scientists, accountants, management consultants. There's over 60 professions and occupations on the list. So really, if you have an individual who is coming from Canada and you want to know whether or not they would qualify for TN status, the best thing to do is to provide us with their credentials, provide us with your job posting, so we can determine if the job posting, the position you're trying to fill, is a TN occupation, and then also whether or not the individual you're looking to hire in that position has the minimum qualifications. So this is a sample org chart that we found that might apply to your situation. And again, this is just for matters of this discussion. And if you look at the positions that are circled on here, and you're thinking from a TN visa perspective, these are the types of roles that could potentially qualify for a TN visa. So a production manager, let's say it's a production manager and that manager is an engineer and works in the engineering profession. Well, engineers are on the TN occupations list. If that individual has a degree in engineering or is a licensed engineer or professional engineer, they could potentially qualify for a TN as an engineer. A manufacturing technician. So a technician, if it's in the field of engineering, scientific engineering technician, technologist, is also an occupation that is under the TN occupations list. And if that individual has a proper experience and training, that individual reporting to a engineer or a licensed engineer could potentially qualify as a scientific engineering technician, technologist, and potentially a maintenance technician, if it meets that criteria, could potentially qualify for TN status as well. And if you move over to your finance department, your accountants, or your individuals that could be classified as doing the work of an accountant, well, accountant is also an occupation that is listed under TN occupations list. And when you're looking at TNs, it's important to note that you have to have a degree in a closely related field. So if you're coming in as an accountant, you should have a finance or an accounting degree or a CPA, CMA designation. Same thing with engineers, engineering degree, professional engineer. Tech specialist and your IT department, if you move over to your IT department, that could potentially be maybe a computer engineer or a computer systems analyst or related occupation in the computer field. And somebody who has a degree in computer science could potentially qualify for TN status in either the computer engineering or the computer systems analyst occupation. And the rest of those occupations that we left uncircled typically would not qualify for TN status. Not saying that they couldn't, depending on that role. So these are the ones that typically would. If you do have individuals in these other roles, there would have to be a more in-depth discussion about their duties and their qualifications to determine whether or not it could potentially. Moving on to the H-1B, and the H-1B is the one that most people are very familiar with. H-1B is for those working in a specialty occupation in the United States. Well, specialty occupation is defined as occupation that requires at least a bachelor's degree in order to enter into that field. So the minimum entry requirement would be a bachelor's degree. And this is subject to the cap, it's subject to a lottery. That lottery is going on right now. We should have the results by the end of the month for who got into that lottery. And that lottery is for individuals from all over the world. And there's 85,000 total H-1Bs available. 20,000 are reserved for those that earned a master's degree or higher in the United States. And the other 65,000 are available for people with just a general bachelor's degree or higher. And the H-1B initially will be approved for 3 years with 1 3-year extension, a maximum of 6 years. One of the advantages of the H-1B is it is a dual intent visa, meaning that if you are going through the green card process, you can continue to travel while you're going through that green card process. The H-1Bs, in addition to the lottery, where we'll know officially once the lottery results end, at the end of this month, what the odds were this year. But typically, you're looking at less than somewhere between around 15% of a chance of getting this H-1B lottery. And that all depends on how many people actually enter into the lottery. And the process is a little more cumbersome than a TN. You have to get approval with USCIS. You also have to do a labor condition application with the Department of Labor, attesting to the wages and the working conditions of that H-1B employee. And there are many occupations that could qualify for a TN. This is where, or for the H-1B, this is where it's broader than the TN. And you can have people in higher level positions qualify for an H-1B. And as long as it requires a bachelor's degree, and you can argue that that occupation requires a bachelor's degree, then you could potentially get an H-1B for that individual. So as far as, the breadth of occupations that can qualify, H-1B is much more comprehensive than the TN. The TN is much more limited. So if you're going back to that same org chart and you're trying to identify which individuals could potentially qualify for an H-1B, well, you can qualify from almost all the way at the top of your organization, almost to the bottom. And almost to the bottom because individuals, frontline employees, typically some of those positions don't require a bachelor's degree. Maybe it requires an associate's degree. Maybe it just requires experience. So if you're looking across your org chart, those roles, you can argue as long as that role would typically require a bachelor's degree, would qualify potentially for an H-1B. One of the things I would point out with an H-1B is the lottery is probably the hardest way to get an employee on an H-1B, and entering that employee yourself into the lottery. If, however, you run across somebody who does apply for a job within your organization who already has an H-1B, who is already issued an H-1B and is working for another employer, that's the easiest way to get them because they don't have to go through the lottery again. You can transfer the H-1B over to you as the employer. You can take advantage of the fact that they already were entered into the lottery and do a transfer over to your company. So if you have people who are applying who already have that H-1B and have already been working in the United States on it, that's to your advantage because then you can skip that whole lottery part because they already went through the lottery. You don't have to go through the lottery again unless you use all your available H-1B time. Now I'm going to turn it over to Christine, who's going to cover L-1 visas.
So L-1 visas are a little different than H-1Bs and TNs because there is more limited eligibility for these. The people that can apply for L-1s are employees of they're intercompany transferees. They're employees of multinational organizations who have worked outside of the United States for at least 1 year in the last 3 years for a qualifying organization. And a qualifying organization is an affiliate outside the United States, a branch outside the United States, or a subsidiary or parent company outside the US. So these employees are already within the organization, and it's really considered a transfer within the organization. And L-1s are actually limited to certain employees, although not limited by qualifications so much as the H-1B and the TN. It is limited to executives and managers if you're qualifying for an L-1A. And that means manager level, we're talking about second tier manager. So a manager that has at least two tiers of employees beneath them. That first line manager wouldn't necessarily qualify for an L-1A visa. There are managers that can qualify for L-1A visas, and those would be functional managers. So managers of a function within the organization that maybe they're managing the, R&D outside of the US, and you want me to transfer into the United States now. The L-1B candidates would be people that hold specialized knowledge within the organization. So typically we see this with our tech employees that have technological knowledge of the product or the procedures within the company. Perhaps they're not managing anybody, but they have obtained this knowledge through employment with the company for at least 1 year. And it's kind of a little misleading, because even though the employment for 1 year has to happen, they really want to see that they were 1 year at a specialized knowledge level. So it typically entails at least 2 years outside the United States, because they would need some time to acquire that knowledge. The benefits of an L1: there's no degree requirement. I already mentioned that. So, the H-1B is limited by bachelor's degree. TN is limited by the education that's required for that profession. You can apply for an L1 with 0 degrees. Perhaps you just have job experience with the company outside the US, and that's what you're qualifying on the basis of. Another key benefit of the L1, which is very different from the H-1B and the TN, is it is a direct path to a green card, where you actually get to skip a step in the green card process, which we call PERM, but is a test of the labor market and an application with the Department of Labor to make sure that there are no qualified American applicants for that position. And H1 or L1B, L1A visa holders can transfer to EB1C or green card holders by skipping this step and just going straight to a petition from the employer. So it's a great benefit to those employees, those L1A executives and managers who want to move to a green card eventually. The common uses in the manufacturing industry is going to be moving your managers, your R&D leads, as I already mentioned, certainly engineers and executives, your C-suite executives are going to be eligible for this as well. And engineers would need to be either a functional manager managing the engineering function of the organization, or at least being a managerial level employee where they have engineers working beneath them, professional level employees working underneath them in the organization. If we look at the organizational chart that we've been sharing with you, we can easily identify those that would qualify for L1A as, your C-suite president, vice president, and certainly these managerial level positions or director level positions, depending on how you classify them, that fall beneath the C-suite. Once we get beneath that level of in the organization, so we're looking at perhaps a production manager, there is a chance they could qualify for L1A, but it's going to depend on who they're managing and what the hallmarks are of their position and their duties in their position. And then L1B candidates are going to be focused more on usually the positions that are technology related, so your IT positions, but it certainly could be some of these lower level positions as well, depending on what information they hold about the company and its products and procedures and its processes. So, you can transfer, and it's really for the sharing of knowledge, right? So that you could transfer those people into your US company. They're going to bring that knowledge that they've gained outside the United States working for a related organization to the US, hopefully to teach and train some US employees in how to do what they can do. So the last visa option we're going to talk about today is the E1 and E2 visas. And these visas are based on a treaty between the United States and another country. So Canada and the United States are in a treaty like this, where people that perform, either trade with the United States, or their business invests in the United States, or they personally invest in the United States, they can get a visa to come in and continue that trade with their US clients, or continue to manage their US investment. That treaty requires that people that apply for these types of visas attend a consular interview, and it's processed through a consulate, which is very different for Canadians than the L-1, TN, or H-1B, because those don't require a consular interview. You can, in most cases, apply at the border, or in the case, in most cases, get approved through USCIS and just show up at the border with your approval notice. The E-1 and E-2 are very different. That consular interview takes place with the Department of State, so it's a completely different organization. In order to qualify for an E-visa, an E-1 treaty trader would need to be a Canadian company or perhaps a manufacturing company that does business with with US clients, and at least 50% of their international trade is done with the US. So that's not 50% of their total trade. They could have a large domestic trade as long as 50% of all their international trade is conducted with US clients. And so that's how a Canadian manufacturing company would qualify for an E-1 visa. That company would need to be registered with the consulate, and then there's a possibility that E-1 employees could also come to the United States to conduct that trade as well. So it doesn't just need to be the owner of the business or someone higher up. Once that registration is in place, you could get a visa for employees to come in and conduct that trade on your behalf. And the other E-visa that's available is the E-2 visa, or that we're going to talk about today, because there is an E-3 for Australians, but we're not going to go into that. The E-2 visa is an investor visa. It's specifically for people that are either purchasing a US business or making an investment into a US business. And there needs to be an ownership that happens where at least 50% of the ownership is a Canadian. Okay, so that if you have a large number of shareholders, that can mean producing the passports for all of those shareholders, which can be a little bit onerous in companies that have multiple owners. But if you're a Canadian business owner and you would like to expand to the United States, sometimes the E-2 is a better option than the L-1. The L-1 coming over as an executive or manager, the E-2 coming over as an investor. Specifically, we see E-2s being used by Canadian businesses expanding to the United States, where those Canadian businesses may want to close that Canadian office, right? And they just want to move the whole business to the US. So it's great for that. The benefits of these E-visas are that they're valid for 5 years. So you heard Jeremy talk about the TN maxing out at 3 years and having to renew there, and then the H-1B maxing out totally at 7 years. And the L-1 has a maximum or 6 years, sorry, Jeremy, and then a maximum of 7 years for the L-1A and 5 years for the L-1B. The E-2 is the first one you get is valid for 5 years, and you can continue to renew that indefinitely. You just need to make a visit to the consulate, submit a new application, and get another 5 years on that. The common uses in manufacturing are going to be, like I talked about, expanding an operation that's outside the United States to the US, where perhaps you want to close that facility in the country where it was started, and establishing centers in the United States, distribution centers, branch offices, maybe production facilities here in the United States. Where you're going to make an investment in doing that.
All right, thank you, Christine. So before we get on to this next slide, we did receive some questions, and I failed to mention at the beginning that we would love to have your questions. If you have questions, we would prefer to answer your questions rather than read some generic slides. So thank you for those that have submitted questions. We have a couple of questions we're going to get to right now before we move on. The first question was, what if I had a TN refused at the port of entry and was told to apply for an H-1B, and this person, what did they apply as? What? As a project manager. So it's very important when you're applying for a TN. A TN is, when you're looking at the occupations list, it is a visa category. It's an occupation. It's not a job title. And that's probably one of the most common errors that people make when they're applying for a TN, and employers as well. They will send an employee to the border to apply as a project manager. Project manager is not an occupation on the TN occupations list. That's a pretty easy denial in most cases for a border officer, because they can't line that up directly with an occupation. Well, project manager of what? What is your actual occupation? So it's very important when you're applying for a TN to identify the occupation and apply under the occupation, not your internal job title. You're applying for a visa. You're not applying for a job. And I think that's a very important distinction when you're applying for a TN. You're applying for a visa, not a job. And that's why most job offer letters won't work for a TN application, or even applying under most job titles won't work for a TN application because it does not align with the TN occupations list or the visa categories that are available. So when you're trying to identify which occupation, we'll look at your duties. Duties are the most important determining factor as to what you actually do for TN visa purposes. As a project manager, are your duties primarily that of an engineer? Are you managing engineering projects? Well, then the proper occupation might be engineer and not project manager. And you apply under the category of engineer rather than the category of project manager. So this individual specifically says cybersecurity project manager. So cybersecurity project manager, that depending on your education and your duties, that could potentially qualify under a computer systems analyst or a computer engineer category. So that again is not an occupation on the list. However, depending on what your actual duties are and what your education is, it could align with a TN occupation under computer systems analyst or computer engineer. So again, it goes back to what are your actual duties? What is your training and education? And does that align or can it align with one of those TN occupations and then applying under one of those occupations? Now, if you've already been denied at a port of entry, that can make it a little more difficult to reapply. And it could mean you have to apply by mail with USCIS, which I did not discuss, but Canadians do have both options. Typically, a Canadian is just going to go to a port of entry, however, because it's faster and it's cheaper. Some situations, however, do justify getting pre-approval by mail with U.S. Citizenship and Immigration Services, and it might apply if you were previously denied to get a second opinion through USCIS. And what happens there is you file it by mail with USCIS. They would then issue what's called an I-797 approval notice. And then that approval notice would then be taken back to a port of entry to seek entry under that pre-approval. But it really depends on the factors involved in that refusal. And again, going back to internal job titles, education, duties, very important when you're doing the TN process that everything aligns with an occupation on the TN occupations list. It's very it can make the process words are it can make it very difficult to apply for a TN if you're just trying to apply under an internal job title and you're not aligning that or syncing it up with the proper occupation on the TN's list. A lot of people are denied that way. Second question. What if you're already in the United States on an H-1B and you're trying to go to a new employer? Does the new job have to be the same job that you got your H-1B for? Is that the right question? The answer is no, it does not have to be the same job, but it has to be a specialty occupation, meaning if you are going from one employer to another, it can be a completely different job than the one you currently have, as long as that job also requires at least a bachelor's degree. So the specialty occupation is the underlying factor there. Very different from a TN. It doesn't have to be a specific job title to qualify for the H-1B. As long as the industry standard is that that job requires at least a bachelor's degree, then you can argue that it for an H-1B and you can transfer.
And the person's bachelor's degree is related to that role as well.
Correct. And that applies to TNs, right? As well. Both of those, the degree lining up or being consistent with what you're doing is very important. And one more question. This one right here. As an employee for TN renewal, is it still true that we can start the process only 6 months in advance, like you said, even if we are doing it via post mail rather than going to the border. So if you're doing it by mail, you can do it up to 6 months in advance, and you can't do it more than 6 months in advance. However, if you're doing a port of entry, it has to be within 10 days. So if it's in person at a port of entry or pre-flight inspection, it must be within 10 days of the intended start date. So the 6 month in advance is only if you're filing by mail with USCIS. Also on a TN, can I change my intent? And if so, how much time should I have before my TN expires? So that's a good question. I'm assuming that question is regards to and going to a green card. And yes, your intent can change under any visa status. The important thing with a TN is that at the time you're applying for the TN, so at the port of entry, your intent is non-immigrant, that your intention is just to work temporarily on that TN. Can your intent change after you get that TN? Maybe you've been working in the US for a year, 2 years, whatever on that TN, and now you want to move to a green card and your employer is willing to sponsor you. Absolutely. Your intent can change and you can have your employer assist you with that green card process. It does get a little bit complicated, and you need to make sure that you have valid TN status throughout that transition process, and you don't do it too early. Typically, intent, there's a cooling off period of at least 90 days. If you change your intent sooner than that, then it could become an issue for immigration purposes. But you can absolutely go from a TN to a green card. It's the same process actually as going from an H-1B to a green card. Same exact process. It's through PERM or through marriage to a U.S. citizen, or through sponsorship from a qualifying family member. It's all the same. But yes, intent is an added factor for a TN individual, and you need to make sure you pay attention to that. So when it comes to visa statuses, you can only hold one visa status at a time in the United States, meaning you can't come in the United States on a TN and an H-1B at the same time. No, you cannot. You're either admitted on an H-1B or you're admitted on a TN, or you're admitted on an E or an L. You could be admitted on any of those visa classifications at a separate time as long as you qualify, and you can go between any of them as long as you qualify, but you can only be in the US under one status at a time. So if you go from TN, you can go from a TN to an H-1B if you qualify. You can go from an H-1B to an E if you qualify. As long as you qualify, you can change between visa statuses, but you can only be in the US under one of those statuses at a time. Anything you want to add there, Christine?
No, I think that question probably stems from a situation if somebody's working for an employer and they maybe have a side hustle, they want to start their own business and make an investment in a US company. So, you can do it, but you just have to be a silent investor. Unfortunately, you can't manage that investment because you can't hold an E2 or an TN at the same time.
All right. We do have another question. I think we're going to cover that, though, at the bottom of this slide. So green card process. Green card, if you want to be in the U.S. permanently, if you love it here, you have a good situation with your employer and you want to make it long term, well, visas are temporary. They're meant to be renewed. Some of them have maximum limits. L-1A, 7 years, for example. L-1B, 5 years. H-1B, 6 years. So visas are meant for temporary work in the United States. If you have a permanent role or want to make it permanent, that's where a green card comes into play, or what is referred to as lawful permanent residence, or being a permanent resident of the United States. Now, the best part about a green card is not only do you don't have to go through a renewal every 3 years, every 2 years, or every 5 years like other visas. Typically, it's going to be a 10-year green card if you get it through employment. And it has a path to U.S. citizenship. After you have that U.S. green card for 5 years through employment, then you can apply for U.S. citizenship and become a U.S. citizen. And then it's broken down into different categories. I'm not going to get into too much detail about those categories, but depending on what your role is in the organization, there are different categories and subcategories for every type of worker, all the way down to your frontline worker, can be sponsored for a green card through the perm process, all the way up to somebody who could be super specialized and maybe they are at the top of their profession in the entire world. They could possibly self-sponsor. So when you're looking at the green card process, it comes down to what the role is, what the qualifications are to determine which category that person might be sponsored under. But if you're looking at long-term employment, green card's the way to go. And it also is highly dependent on where you were born. And that's where a lot of people don't understand. But wait times, it's like when you go to the DMV, you get a number to wait in line until they call you up, and then they'll, review your application. Well, green cards is the same thing. Depending on what your category is, whether it's EB1, EB2, or EB3, like it shows on this slide, and your country of birth, it's going to determine how long you have to wait for that green card to be issued. And you get what is called a priority date when your employer files for you. And then your priority date is your place in line. And when your place in line gets called up, then you can officially request the green card based on that permanent labor certification. And again, you can have jobs that require minimal training all the way up to highly specialized jobs, and those require, high levels of education and training that can be sponsored for the green card. And there was a question on the green card process specifically about
EB3
the EB3 process,
and the process and the
premium processing. That's a common question that we get about the green card process is premium processing. So in order to answer that question, it's actually more complicated than it seems. There are multiple steps to the green card process. And if you're going through permanent labor certification, the perm process, whether it's EB2 or EB3, it doesn't matter. It's the same process. Premium processing only applies to the final, to the filing of the I-140 petition, which can only be done after labor certification is approved. The delay in the green card process is typically the first step, the recruitment process, the labor certification with the Department of Labor. That process takes a long time. Right now, it's taking 2 to 3 years just for the recruitment and labor certification. That process with the Department of Labor cannot be premium processed. There's nothing you can do to speed that up. You're going at the mercy of the Department of Labor and their backlog. You can't do anything about it. Now, after you get the labor certification and your employer files the I-140 petition, that petition itself, the I-140, that can be premium processed with USCIS. And that's a 45 business day premium processing. But it's important to understand, even if you use premium processing for that I-140 petition, you're still subject to the visa bulletin. So if you're from a country that has a backlog and there's a 5-year wait just because where you're born, well, premium processing isn't going to move you up in line. You're going to still process according to your priority date. So premium processing typically doesn't make sense for an individual unless their priority date is what is called current. In other words, they are currently processing cases according to your priority date. In other words, you're at the front of the line. That makes sense to premium process because then you can immediately transition over to a green card and you don't have to wait. But if your priority date is backlogged, maybe you're from a country like India, for example, with excessive backlogs, and it's a 15-year wait, doesn't make sense to do premium processing because you're going to be waiting 15 years no matter what you do. However, if you're from Canada, maybe you were born in Canada, and the priority date is what is called current. In other words, there is no backlog. Well, then it does make sense to premium process because it's going to move your case along faster because you do not have to wait in line because you're at the front of the line. And it gets a little more complicated. So if you do have more questions about that, we'd be glad to answer those offline as well. All right, so do we have any more questions? Okay. We do have a few upcoming webinars for those that might be interested, where we're going to be talking about the H-1B lottery results and what to do and alternatives to the H-1B lottery if you don't get in. Also, a more in-depth conversation about TN visas for Canadians, how to qualify and apply. And here is a QR code and our contact information for anybody that does have questions. Feel free to reach out to us directly. We deal with all U.S. immigration law. So if you have any U.S. immigration law related questions, whether it's TN, H-1B, L, green card, family-based, employment-based, we can assist you with that. So any questions that you might have, feel free to reach out to us directly. Otherwise, thank you for your questions. We love those questions and your engagement with us today. And thank you for joining us during your lunch break. And have a great day.